This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This tutorial will provide a step-by-step guide to completing Form AOC-E-100, the Application and Assignment Years Allowance. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Applicant, the person who is applying for a year's allowance for themselves or on the behalf of the decedent's surviving spouse or qualifying child. Affidavit, a sworn or affirmed statement that has been made under oath. Affiant, the person who is making a sworn or affirmed statement under oath. Personal representative, a person who has been appointed to administer an estate. This term may refer to an executor, an administrator, or an administrator CTA. Probate, the legal process in which the decedent's estate is administered. When is this process used? A surviving spouse of a decedent who lived in North Carolina at the time of the decedent's death may apply to the court in the county where the decedent lived for an allowance for a year's support of up to $60,000 out of the decedent's assets. If the decedent did not live in North Carolina, but the surviving spouse does and the decedent left personal property located in the state of North Carolina, the spouse may apply to the court in the county where the personal property is located for the allowance. An allowance of up to $5,000 from the decedent's assets is available to a decedent's surviving child under the following circumstances. The child is under 18 years of age. This includes an adopted child or a child with whom the decedent's widow is pregnant at the death of her husband. The child is less than 22 years of age and is a full-time student. The child is under 21 years of age and is either totally disabled or has been declared mentally incompetent. The allowance is also available to a person who is not the decedent's child, but who is under 18 years of age, who lived with the decedent at the time of the decedent's death, and for whom either the decedent or the decedent's surviving spouse stood in the place of a parent. What are the limitations on using this process? The application must be filed within 1 year after the date of the decedent's death. The year's allowance is not available to a deceased father's child who was born out of wedlock, unless the deceased father recognized the paternity of the child by deed, will, or other paper writing, or unless the deceased father died prior to the child's birth or within 1 year after the child's birth, and paternity has been proven through DNA testing. If a child who has been granted the year's allowance does not live with the surviving spouse or a surviving parent, and there is no court-appointed guardian of the child's estate, then any funds due the child from the decedent's assets will be kept by the Clerk of Superior Court until the funds can be paid to the child when he or she reaches 18 years of age, or until the clerk authorizes the payment of the funds for some purpose that is in the child's benefit. What must the applicant provide to the clerk's office when seeking approval of the year's allowance? In addition to the completed application and assignment year's allowance form, the decedent's death certificate must also be provided. The marriage affidavit must be completed if the application is for a surviving spouse. All available documentation of the decedent's assets is needed. These documents may include bank account statements, vehicle registration and/or title, vehicle value, check copies, or other proof of ownership and value. The clerk's office also requires a family history affidavit to verify that the decedent's spouse and/or children are listed correctly on the application. Instructions for completing the family history affidavit can be found in a separate tutorial. If the decedent left a last will and testament, the original document must be filed with the clerk of court. The General Court of Justice fee for processing the application is $20. Include an additional $3 for each asset that will be assigned on the year's allowance. If there is a will, add $1 plus 25 cents per page of the will after the first. Acceptable forms of payment include certified check or money order. Cash, credit, or debit cards may be used if you are paying the fee at the courthouse. How to complete the application and assignment year's allowance. Enter the county where this form will be filed. Enter the decedent's name and date of death. Note: if there is a vehicle in the decedent's name, the name printed on the form should match the vehicle title exactly. DMV will not accept documentation if the name on the form is not exactly the same as it is on the title. Indicate whether A, the decedent died a resident of this county on the date shown above, or B, the decedent did not die a resident of this county, but personal property that belonged to the decedent at his or her death is located in this county. Read statement number 2, along with the note found below on the left side of the form. Verify that each spouse or child who will be listed is entitled to the allowance based on the information found in the note section. Indicate whether you are requesting assignment of A, $60,000 to the surviving spouse, B, $5,000 to each child named below from the decedent's funds or personal property, or both. If there is a surviving spouse, list the full name, age, and complete address including zip code of the spouse. If applicable, list the full name, age, and complete mailing address of each child who is eligible for the allowance. List surviving children only if they meet the criteria established earlier in this tutorial and stated in the note section found on the application below the spouse and children's names. Enter the name and complete address of the applicant, as well as telephone number. If the applicant is one of the persons listed above, this information should be entered a second time in this section. When the form is completed, the applicant must date and sign the form. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This will typically be a licensed notary public. Indicate whether the applicant is A, the spouse of the decedent, B, personal representative of the estate, C, guardian, D, an adult child who is a full-time student, E, next friend of child, or F, other. If other is chosen, print on the line the applicant's relationship to the decedent. Note: if filing as the surviving spouse's attorney in fact, please provide a copy of the registered power of attorney. Submit the completed, signed, and notarized form with these items. Death certificate. If the application is being submitted for a surviving spouse, a completed, signed, and notarized marriage affidavit. All available documentation of the decedent's assets. The completed, signed, and notarized family history affidavit. If the decedent has a will, the original document, a cashier's check or money order for the filing fee, payable to Clerk of Superior Court. If the application is approved, the clerk's office will complete a list of personal property that has been assigned to the spouse and/or for the children's benefit. A certified copy of the application and assignment will allow banks or businesses to release the listed assets. After preparing your paperwork in accordance with this tutorial, you may bring your documents and the filing fee to the Mecklenburg County Courthouse and drop them off, or you may mail these items to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.